The Second World War ended in 1945, so 76 years ago. Communism collapsed in Poland in 1989, i.e. 32 years ago. Why, despite the passage of so many years, we are faced with a problem of claims by pre-war property owners, and most often their heirs, which must be taken into account when purchasing real estate and which constitute a risk for the transaction? This question will be answered by my today's guest, RADOSŁAW WIŚNIEWSKI, advocate at Wardyński & Partners Property Restitution team. But first, a few words about Polish economy. Welcome in program News from Poland, Business and Law, addressed to foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors. There is a service industry in Poland that is doing great despite the pandemic. These are business services that are exported from Poland to the world, mainly to Germany, Great Britain, France, Switzerland, the Netherlands and the United States. These are accounting, IT, human resources and payroll processes, supply chain support, research and development processes and customer service. In the world, India, China and Malaysia are the leaders in such services. Poland is the leader in Europe. Some data. In Poland, 355,000 people work in this industry in 1,600 business process outsourcing centers, shared service centers, IT centers, as well as research and development centers. Two-thirds of them belong to foreign investors, such as the German chemical and pharmaceutical concern Bayer or the British-Dutch petrochemical concern Shell, whose business operations center operating in Kraków employs 5,000 people. In the pandemic year of 2020, the value of these exports amounted to nearly $23 billion, 16% more than in 2019. This is 34% of all Polish exports of services and 3.5% of Polish GDP. The Polish business services industry very quickly and efficiently switched to remote work in the first weeks of the pandemic, which was difficult, for example, in India, competing with Poland for this type of investment. Employees quickly switched to working from home on their own IT equipment. Optical fiber networks in our country turned out to be efficient and failure-free. The climate also helped the employees. Their home offices did not need air conditioning because in Poland it is cold for 8 months a year and it often rains or snows, and sometimes all these weather conditions occur simultaneously. Yes, it is possible. Poland is no longer considered a cheap location in this industry. Nevertheless, more and more complicated and therefore more expensive, higher valued processes are transferred to Poland from Western countries. Increasingly, they rely on supporting organizational and strategic decisions. Okay, and now it's time for RADOSŁAW WIŚNIEWSKI and reprivatization claims.
Hi. Many investors and their lawyers consider property restitution, or as we call it in Poland, reprivatization, to be a purely historical phenomenon. Is it really? And are restitution claims completely irrelevant to real estate investments in Poland? Let's take a closer look at this issue. In general, property restitution in Poland consists in reviewing the lawfulness of post-war acts of expropriation leading to the restitution of the expropriated property in kind or compensation if the claimants can prove that the nationalization was unlawful. After the Second World War, the communist government deprived private owners of their property under various legal acts. Since the transition to democracy, Poland has never questioned this seizure of private property as such, and consequently never adopted comprehensive property restitution legislation. This is why the property restitution process in Poland is limited to situations where it is possible to prove that the property was taken in breach of the law enforced at the time during the communist era. It was quite common for the communists not to follow even their own expropriation laws during the nationalization of private property. In effect, for the last 30 years, on case-by-case basis, former owners or their legal successors could file claims challenging the communist nationalization process. Given this legal and historical framework, there is no general register or even a list of real properties where it can be simply checked whether relevant property restitution claims have been filed. In consequence, in many real estate investments in Poland, it is necessary to include an investigation of property restitution claims in the due diligence to assess whether the legal title to the property is certain. The purpose of such an examination is to analyze the risk of loss of title as a result of restitution of the property to the former owners or their legal successors. In this regard, the risk of compensation is far less important, since compensation is usually sought from the state treasury or local authorities and not from private investors or developers. However, in September 2021, a new law entered into force that considerably reduced property restitution claims concerning communist-era expropriation. Although this legislation greatly reduces the risk related to property restitution, it does not exclude the risk entirely. Therefore, real estate investments in Poland still need a thorough examination of the risk related to property restitution claims. And what to do if the due diligence report identifies some risk related to property restitution claims? There are different strategies to be followed by investors. If they acquire the property, it will usually be possible for the investors, as the current owners, to participate in various administrative and judicial proceedings and attack each action taken by the claimants. But this is a long and expensive scenario, and the results are uncertain. Instead, very often it is worth reaching a settlement with the claimants. The scope of the settlement can differ greatly and depends on the circumstances of the particular property. Usually, the most efficient solution is to simply buy out the claimants, but this can be pricey. So, many investors decide to structure an agreement with the claimants in a way that determines the legal actions of one party in exchange for the legal actions of the other. This win-win solution allows the investor to secure its legal title to the property and at the same time enables the claimants to complete all the procedures required to seek compensation from the public authorities in civil court. And last but not least, investors in the real estate sector in Warsaw have many doubts with regard to the certainty of legal title to already recovered properties, which allows us to distinguish a risk related to the reprivatisation process in Warsaw. This process has been inspired by irregularities in Warsaw property restitution cases. In 2017, an extraordinary governmental commission for property restitution in Warsaw started its highly controversial activity based on its new interpretation of the communist nationalization rules. The commission invalidates decisions on return of properties and also overturns good faith transactions following recovery of the property. In such circumstances, real estate investors in Warsaw need an in-depth analysis of the reprivatization risk in their current or future investments in already returned properties. With all these factors present, and despite the stricter and stricter limitations on property restitution claims, due diligence in real estate investments still requires an assessment of property restitution risk because the complex history of ownership in Poland still determines the current legal situation of properties in this country.
Thank you for watching this episode. See you soon.